morning, everyone, and welcome to this morning's Employment Rights Act 2025 webinar. So, to introduce us, I'm from Tees. I head up Tees Employment Law team and our Business Law Services team. And for those of you who are new to Tees, we are a full service legal and financial wealth management business, and we like to offer a full joined up service to our clients. And that is for businesses, a wide range of businesses and sectors and organizations, many owner managers, many other organizations, including not for profit. What I think sets Tees apart is the fact that we really do take pride in making the relationships matter and ensuring that we give practical advice alongside the legal advice. And I'm sure that those of you who know us will be familiar with that approach. If you like, we take your work and the work very seriously, but we don't take ourselves too seriously, and we like to get to know you and understand what matters to your business. I'm joined today by Georgie from the team at Tees, who will be speaking through some of the current topics to be thinking about. And I'm delighted to be joined, or if you like, rejoined by Victoria Cooper from We Talent Recruitment. And Victoria has worked with Tees on a number of occasions in different guises, but joins us today from We Talent.
Thanks, Robert. So I'm Victoria Cooper. As Robert said, I'm the Managing Director of We Talent. So we're a recruitment business based in Essex, covering largely Essex and London, although with a slightly agile approach to that. I've been in recruitment for about 25 years, had an early career in HR and then moved into recruitment and worked in corporate recruitment for 19 of those years. And then I started We Talent in 2022. So we've grown to a small business of 5 of us currently. And I always feel like my experience, first being in HR client side, then corporate recruitment, to now running my own small business and still doing the recruitment, gives me a really well-rounded view of the challenges that business face. And it's certainly been a changeable market, and I'm going to hopefully share some insights throughout today that will really help you tackle recruitment and retention and hiring in today's marketplace.
So, as Victoria mentioned, really challenging times for many employers. Many employers have been hit by the national insurance increases and other challenges that are facing businesses across the UK. And what we hope today is to help inform you and assist you in considering the challenges on the horizon, and maybe thinking of them in terms of how you can tackle and navigate those choppy waters and how you can make this work for your business. Every business will be different, and we were talking to you about some things which are common to every business, but mindful that what matters for you may be different to the next business, and that's how we like to work with you. So we'll be talking about areas of immediate change looming on the horizon from April, including the Fair Work Agency, which I will mention briefly now, which is going to be the one-stop shop, if you like, for employees to go and raise their concerns about employers. That is a rather simplistic analysis of what the Fair Work Agency will do. But for you as a whole today, one thing to keep in mind is that the agency, once in place, will, amongst other things, be looking at national minimum wage enforcement. And the idea and the rationale behind it is that there will be a key place that is a go-to place to raise concerns about rogue employers, but it will also have bite and it will have enforcement rights, and that should not be lost sight of. We will return to that and how that will work in future webinars. Then in a moment, Georgie will talk through with you some of those key things around sick pay, family leave and sexual harassment that we believe every employer must know about and must know about the changes and adapt to. I will talk a bit about the changes on collective redundancies and the particular sanctions that may now be imposed, and then we will move from the changes to unfair dismissal from next year into some really insightful information from Victoria about getting it right on recruitment. And all of these different themes will tally up and join up in a way that you hope will be helpful. There's a lot to get through, so I won't pause for too much longer now, but I will now pause to pass over to Victoria to talk about the labour market today.
Thank you, Robert. So as mentioned, I'm going to talk about hiring and retention as we move forward into this year. So just to give you a bit of a snapshot, last year we saw a fair, and I think most businesses did see a fair pause on hiring in spring of 2025, which we largely felt was due to employer costs increasing and some uncertainty in the market at the time. And then coming into the latter part of the summer, certainly autumn, and then carrying on into this year, we've seen a hiring increase. And what often happens when there's a sustained pause in recruitment is you do get that almost bounce, that boom of when hiring then has to move faster. and that is when it can lead to more reactive hiring. And what's really important is that steady, planned and considering hiring is better, because that gets you better outcomes. Like Robert was saying, getting that right hire and managing that right hire in the right way is much safer for your organisation and cost effective. We know that it's a really mixed market. It is competitive to attract and retain the right candidates, and there's definite skill shortages in some areas, but also we know that there are groups of people who are still struggling to find work, so such as we know the younger generation is struggling to get a foot in the door. So it's a very, very mixed market at the moment. We're always asked for our market opinion from clients and candidates we work with, and I always give the caveat to say that it's my opinion and it's largely anecdotal based on what we see and what we hear from our clients and candidates. But what we wanted to do was take that information and make it tangible and usable, so that we could share that with the Essex market, the wider Essex market, and it could help people get better outcomes both for their hiring, whether they're using recruitment partners such as ourselves or doing their own hiring, and better outcomes for retention. Because as recruiters, certainly when we're hiring, we want to place people who stay long term with your business. That's really important. So what we did was we launched a survey, which is actually out in about a week. It's free, and there's some really valuable insights in that about what Essex professionals felt about job seeking, working and managing within the Essex market. So I'm going to share some highlights of that as we go through today, and some key learns which will be really beneficial to you. And obviously, like I say, you can have a full copy of that survey as it's released. So you can see here on the bottom right, so they're the true results of the survey. So actually 75% of people ranked leadership as the most important to them. So leadership, clear, visible leadership within the business. I'm going to touch more on leadership a little bit later on because it came out so high. Workplace culture, also very important, and that came equal with career progression, which I think scored highly on our results. Work-life balance was still there, but falling slightly behind, and salary came at the bottom. So it was important, but it wasn't the key and only driver. So personally, as a recruiter, I felt that was really refreshing to see that people are wanting to move for that culture, that leadership, that opportunity, and it isn't just a salary conversation before, like it has maybe been in the past. So that's the highlights of that. Just to touch on the slides on the left, and just really key to note, and this is very important. So 65% of professionals are currently considering a move within the next 12 months. That is huge, and that kind of movement obviously means a lot of change within business. But what is important to note there is that people are cautiously looking, which means that they're potentially testing the water for the right opportunity. So that's important for two reasons. Number one is now is the time to focus on retention. So looking at retention drivers, internal progression, and things that I'll share a little bit later. But also that if you are hiring, you need to go that extra mile to make that role attractive to the right people, and think about that whole spread of highlighting benefits such as mentioned on the drivers, so leadership, workplace culture and so on, and I'll share more about that later. Progression also, and I'll touch on this a little bit later on. But we know it's important. People want progression, and I'm going to explore what that looks like and how you might be able to achieve that. So I'm going to hand back to Georgie now, who's going to go through her slides on the employment law side, and then I'll be back to you a little bit later with more on hiring and retention. Thanks, Georgie.
So the first change that I'm going to talk to is coming in April, and it's a change to the statutory sick pay rules. This is quite technical, so please bear with me, and there should be some really relevant and useful tips for businesses in and amongst the technical sections. So as a starting point, under the current rules, to qualify for SSP, you must be an employee who has done some work for an employer, who earns an average of at least £125 per week, and who has been ill or off work for more than 3 days in a row, and this includes non-working days. Sections 10 and 11 of the Act will enable SSP to be payable from the first day of sickness absence, and this will be done by removing the 3-day waiting period. And it will also remove the lower earnings limit for SSP eligibility. Employees will therefore be entitled to the current rate of SSP or 80% of their weekly earnings, whichever of the two is lower, and this will be from the first day of sickness absence. So, how is this likely to impact your business? Businesses should factor in a greater number of employees being eligible for SSP and that this will be from the first day of absence. This will impact payroll configuration and HR processes will need to be changed. Short-term absence costs will likely increase and absence patterns are also likely to change. Consistent absence management and sufficiently evidenced absences will become even more important, particularly as businesses will face an increased exposure to claims if staff are not paid what they're entitled to, and this will include claims for discrimination or unfair procedure claims. So what action can you take now to mitigate this? In other words, what action should you take before April? Sickness absence policies and payroll updates should be in line with the new rules, as should company footnote requirements. Ensure that managers receive updated guidance on managing sick leave and SSP. You should also review employment contracts to ensure that SSP, contractual entitlements, and phased return practices are all aligned. You should also update policies across the board and cross-check that they align with the legislation and each other. These are areas that legal or HR advice may be beneficial in order to future-proof your contracts and policies. Keep it consistent across the business. The same rules must apply to everyone to ensure fairness. This will be made easier by ensuring communications and record keeping are standardized. Finally, this may represent a good opportunity to review and refresh your company's approach to mental health and stress-related absence, just to ensure that this is up to date and in line with the new rules. Moving on to the next change coming into effect in April, and this is in relation to family leave, paternity and parental leave. Under the current law, fathers have to have worked for 26 continuous weeks in order to take paid paternity leave. Employees with a child under 18 must have 1 year's continuous service to take unpaid parental leave. These requirements will both be removed by sections 15 to 17 of the Employment Rights Act, so that both paid paternity leave and unpaid parental leave will become day one rights. The ERA will also remove the restriction on taking paternity leave after shared parental leave. The new rules will apply to babies born on or after the 6th of April 2026, or whose expected week of birth is on or after that date but they're born early, and the same for adoption, it will be the date that the placement is due. So again, what's the impact of these changes on your business? These changes will impact your business's policies, and there'll be a potentially greater demand on resourcing with more parents taking leave, and this will have a particularly big impact in smaller teams and operational roles. There's also the risk of the rules being applied inconsistently, as I said, if the different managers apply different rules. So what can we do about this? Areas to address before the changes come into play include updating family leave policies, intranet pages, employee handbooks, HR workflows, and template letters. Given that the rules are changing, this might be a useful time to create a one-page crib sheet for managers that covers topics like different types of leave, notice requirements, documentation, and guidance for how the work should be handed over before a staff member goes on leave. You should also review your return to work process and ensure that it is fair and consistent across the board for all staff members, and that this process is clearly documented and evidenced. This will reduce the risk for claims for, among other things, detrimental treatment in relation to areas like performance management, allocation of work, or promotion decisions when a staff member comes back from leave. Getting it right from the outset with a well-evidenced, fair, and consistent process will reduce the risk of claims. Professional advice may assist to ensure that a legally sound process is in place to begin with. However, we're often contacted later down the line, and if for whatever reason the correct process has not been followed, we can also help at this point to mitigate and manage the risks. The final change that I'm going to talk about today is to sexual harassment and whistleblowing. The Employment Rights Act will strengthen protections for victims of sexual harassment. For the first time, it will explicitly state that complaints of sexual harassment will be treated as a qualifying disclosure, which means that they may benefit from whistleblowing protections against detriment and unfair dismissal. Section 23 of the Act includes as a qualifying disclosure from April any disclosure that sexual harassment has occurred, is occurring, or is likely to occur. Although sexual harassment complaints are arguably already qualifying disclosures in many cases, explicit legislative recognition will help to dispel ambiguity and also to help raise awareness among victims and potential whistleblowers. So what impact will this have on your business? This will change the scope of how your business should investigate sexual harassment complaints from April onwards, as they should now fall within your whistleblowing policies. Any mishandling of a complaint may then trigger a whistleblowing claim, including for detriment or dismissal following disclosure of sexual harassment allegations. Therefore, investigation quality and response time will become critical. In order to avoid bad process, your business should ensure that any grievance and ensuing investigation is clearly separated from any concurrent performance management that might occur. The two should not become blurred. It's also crucial that this separation is clearly documented and evidenced. So there are some minimum controls that your business should put in place now, not only to get it right first time, but also to demonstrate that your business is doing the right thing, and this is done through evidence and record keeping. Make sure that you have a published zero tolerance policy to sexual harassment, and possibly consider also putting up zero tolerance posters that can be displayed around the premises. This, along with promoting a positive and open workplace culture, will make your business's position on sexual harassment clear. In order to take control of the risks, we recommend you have a single intake route and triage with clear response times, which will take into account any legal and HR considerations in that timescale. It'll be helpful to have an investigation plan template and evidence checklist. And as a part of this, we'd also recommend training for managers on what to do within the first 24 hours of a sexual harassment complaint. Again, record keeping will be crucial to demonstrate reasoned decisions, steps taken, outcomes, and follow-up. So some examples of how to avoid bad process and things not to do. Avoid pushing for an informal resolution where allegations are serious, particularly if you're not going to document why you have chosen to do so. Do not allow the complainant to be performance managed without clean separation and evidence, as this will risk claims for detrimental treatment and dismissal following a protected disclosure. Where these types of issues do arise, or if you're in any doubt at all about how to manage a sexual harassment allegation or investigation, please seek professional advice. And now, for the fourth and final Employment Rights Act change coming in April that we're going to talk about today, I'll hand over to Rob to talk about collective redundancy.
Thank you, Georgie, and a really good run through some of those key things that we think all of you, every employer and every business and organisation needs to be aware of, and hopefully with some helpful practical tips there. And if we look at those practical tips, and we'll carry on with this theme through today, keeping in mind that this is about keeping to the law and legal adherence and keeping up to date, but it also is, as both Victoria and Georgie in different contexts have talked about, ensuring that you maintain a good culture, a positive culture, and that the reputation is there for your business when you're looking to attract and retain talent, and leading from the front and demonstrating leadership, and crucially for us as your lawyers, keeping an evidential trail that you've done the right thing if there is a claim, are all key elements that we hope are helpful to keep in mind. time moving on, I will now move on to our fourth change coming in from April, which is the significant changes around collective redundancy. It's not lost on us that the first three changes are ones that we think will affect every business in one way or another. The fourth may affect your business at times and not at others, but it's one that you do need to be aware of. And we're talking about collective redundancies here, meaning for now, 20 or more redundancies at one establishment within 90 days. You'll see that the trigger for collective consultation, though, will be in due course changing so that there will be a threshold number of employees who would be at risk of redundancy or where redundancy is proposed within 90 days across establishments within an organisation. So it will no longer be at one place, and that will broaden the scope and remit of these rules and where these rules can bite, in short. The further sting in the tail is that the punitive protective awards will from April increase from 90 to 180 days. They will be doubled in part to put off and incentivize potentially rogue employers to do the right thing. But they could, of course, have a significant impact on your business if you unwittingly get it wrong. And it's worth keeping in mind that 180 days is uncapped. And it's worth keeping in mind that 180 days is in addition to any separate claims brought by individuals for unfair dismissal. Now, the way that the rules work is that the notification requirements and the process to follow means that there must be a fixed period of at least 30 days consultation before the dismissal, where there's 20 to 99 employees proposed to be made redundant, or 45 days of consultation with employee reps for 100 or more redundancies proposed. This is different to the individual consultation you will do with individual employees post that event and or where you have less than 20. The two sit side by side and are not mutually exclusive. So you can see that it's a very high financial risk to employers. And there is a fairly prescriptive process to follow. And a failure to follow the process will result, as I've said, in this punitive award. It's intended as a sanction. It's intended to make employers sit up and think, we've got to follow this process. And you have to, again, document it. If you do not document it, you will be liable for criticism and potential claims. You need to go through the process, a fair process of election of employee reps. And the real kicker for many employers is being able to demonstrably evidence that you have not made predetermined decisions before the consultation takes place. It is okay, and the trigger for the collective processes is to propose redundancies. But if your decisions are absolutely crystallized and final, and you know who you're going to get rid of and how you're going to do it and the numbers, that is not allowing for meaningful consultation. So you need to be really careful about ensuring that you enter into this process as soon as you can, mindful of the time it takes, and with an open mind to listening to the reps' feedback and documenting that you have listened to the reps' feedback, and consider this in ways to try to avoid or minimize the impact of redundancies. Now, with the new rules coming in place with regard to aggregating the numbers, you'll also want to think about the triggers. And what good looks like, we think, is ensuring that you have the right people within your business who are keeping a tally of the numbers at risk, having a single point of control, and making sure that you're not trying to make decisions in silos will, of course, help. Keep in mind also that redundancy for these purposes will be broadly defined and will include, for the avoidance of doubt, volunteers. So there is no easy way out of this. It also speaks to the fact, and we talk about this a lot because this comes back and affects our clients routinely, is that sometimes calling a termination of employment a redundancy, when in fact it is, for instance, a performance or even a misconduct issue, but you think that redundancy may be a more dignified way forward, could come back and sting you if that is within a period when there are other redundancies being made and it adds to the tally of numbers of people being made redundant. Pick the right reason for dismissal. If there is a reduced need of the business for work of a particular kind, if you're not going to replace individuals, that points to a redundancy. If you're looking to change roles so that the old roles are no longer applicable, but there are new roles to go into, that points to a redundancy of the old role. If you have somebody who is consistently underperforming, calling it redundancy under the new regime brings added and more costly risks to your business. And again, and we make no apology for repeating this in all our webinars, keep a clear decision log, document your good practice and steps. When we get a claim brought to us, as Georgie mentioned, often it's somewhere along the line. And if you've got good documentation that you've done the right thing and you can show that you have, we are much better placed to defend either valid or spurious claims than if it's all done on a conversation and verbal communications and thought. There's also the piece around winning hearts and minds. If you have a carefully prepared consultation plan, if you share FAQs so that you can share what your immediate thoughts and responses are to typical questions, if you can set out the business rationale, all of these things will not only help to guard against claims, but will mean that there will be a better process, a more dignified process for those affected who leave the business. And crucially, again, speaking to that piece around attracting and retaining talent, ensuring that the survivors also feel that you've done the right thing by their colleagues. And of course, this is something where you need to seek legal advice early to be best guarded against claims, seeking HR advice, and when you reorganize and look at what you need, thinking again about the recruitment side of things, because increasingly in the climate that we're going to get into in a moment, that will become crucially important. And that I think brings me to my next slide. So at prior webinars, we've talked about the looming changes around unfair dismissal rights being brought in sooner, and we now have that confirmed that from the 1st of January next year, there will be protection from unfair dismissal after just 6 months service under Section 25 of the Employment Rights Act, and that 6 months trigger will apply for requesting written reasons. Presently, both of those require 2 years service in relation to an ordinary unfair dismissal claim. I should add that for the avoidance of doubt, these changes do not affect the rights in relation to, say, whistleblower or discrimination claims, which in fact, in relation to such matters, arise arguably before even employment has commenced, and that's something to keep in mind too. Significantly, and moving on from prior webinars, this is a further change, and a significant one potentially. There is the removal of Section 124 of the Employment Rights Act. Now, Section 124 presently places a cap or limit on unfair dismissal of just shy of 120 grand, 118 grand, or a year's pay, whichever is the lower. The median or average award is probably more in the region of around £6,000 based on current stats for the prior year. But the fact of the matter is, this will significantly up the ante. You run the risk in both negotiations and claims of an open-ended exposure where you did not previously for ordinary unfair dismissal claims. It really, really, really impresses upon us, which we would impress upon you, the importance of following due process, having credible reasons for taking action and acting promptly. So amongst other things, we would say don't leave things festering. You cannot afford to now. If you have performance concerns, document them, speak to the employee, ensure that you've offered appropriate guidance, ensure that the employee knows what they need to do properly, and ensure that you have given them an opportunity to improve. But if they do not, that you act and that you elevate and escalate the actions as need be. And act consistently. Because if you don't act consistently, even if you've documented it, you'll be exposed not only to claims for unfair dismissal, but as you can see from the slide, potentially claims for unlawful discrimination too, which will not only be additionally uncapped, but will bring associated claims for injury to feelings. Lots to take in. We yet wait to hear and learn how this will change the way things are in reality. We know that the government guidance is that they think that it may reduce spurious claims based on discrimination because individuals may no longer be pushed in that direction because they can bring an unfair dismissal claim. I raise an eyebrow to that and say, look, you can only do what you can do as an employer. Make sure that you follow the right credible practices, the right consistent practices and fair practices in your business. Be transparent with your staff. And with that, I will hand over to, I think, Victoria to talk a bit more about how we get things right from day one by making sure that we get the recruitment right.
Thanks, Robert. So yes, as mentioned, it's all about getting it right, and setting yourself up for the best success in terms of the hire and then that long-term management, so that you get that outcome and then the candidate gets that career that they're hoping for. And I often provide coaching for small businesses, particularly micro businesses are hiring for the first time and may not know how to hire for their organisation. So the starting point that I always start from, that I'm going to highlight to you today, is starting from the role description. And it's so important to have an adequate and accurate role description. It's very common, and I deal with all sorts of different clients, all different sizes. It's very common to move to hire and not necessarily have the role description ready, or be using an old role description. And it's really important, and a fairly easy starting point, to reevaluate that role description and think, does it accurately describe the role as it's happening now? And does it accurately position it within the team and the organisation? If you've got that role description right, it will help you all throughout this process that you can see on the slide. So you can write your advert from that role description, making it engaging, making it relevant, because that's the first sell of your role effectively. You can interview against that, making sure that you're interviewing against the actual skills and experience needed for the role and the competencies needed for the role. And that's really important in terms of fair and open recruitment. And like Robert said, keeping accurate records and evidencing your decisions of why people are selected or not selected. Also providing feedback, that could be another whole webinar on providing feedback for candidates, but that is also really important. Then you can carry on and use that job description as you move through induction and onboarding. And that's a really good opportunity when someone starts the organisation to sit down with them and reiterate the duties and give them that really honest and open two-way conversation about did they have any questions about how this works in practice, or when they'll learn certain elements that they may not have covered, and how that role fits in the wider context of the organisation. You've got the opportunity then in induction and onboarding to look at that sort of, or talk about that future succession plan within the wider business. And then crucially, as Robert mentioned about probation periods and performance management, you can then use that role description to build straight through your probation reviews and your performance management reviews. So reviewing what actually were we setting out to do, what have we achieved and achieved really well, and what have we still yet to achieve, and how can we offer support around that. Some businesses have HR and L&D teams, and you'll have all this in hand, but if you're a smaller business, it's still possible to achieve these steps, but just by doing slow and steady and paced hiring. It's really important also that you look at your employer value proposition. So as we saw, there's a number of drivers for candidates wanting to select a role these days. It isn't just about the salary or the monetary package, which we'll come to shortly, but it is about that why join a company. So building that employer value proposition into the role description and reiterating it again all throughout that process, it just gives you that real natural promotion of the role and of your business at the interview, again at onboarding, and again sort of for that sort of building that culture and that buy-in as someone goes through the journey of their career with you. So on this slide, we can see a snapshot of what candidates expect today, and this is straight from the results of the survey. So I just mentioned benefits. Benefits are really important. Again, it's not uncommon for people to move to recruitment and not, I guess, be aware of conveying the whole portfolio of benefits. And by benefits, that can be vast. But we're not necessarily talking about financial expensive benefits, because often I deal with small or growing businesses who can't offer the highest pension contribution or best annual leave. And it's about looking at those lighter touch benefits, and often they can be cultural. So that could be a team lunch once a month, or a dress down Friday, or the fact that at Christmas you all get together for a social, or you do something charity focused together. It's important to look at that benefits offering and think, okay, well, what do we offer? If you've worked for the business for a long while, you might not see that as a benefit, but someone coming into you, depending on what those motivators are to them, they may see that as a real benefit. So definitely pulling together that whole portfolio of what can we offer, And if you are looking at improving your benefits package going forward, I always just recommend you're just really creative about that approach and look at things that other people are doing, and look at where some of those may be costly, but some of those might be really more cost effective and easier to achieve. Moving on just to the left, both myself and Robert both talked about reputation and credibility and fairness. Actually, increasingly, candidates are checking online reviews before they join a company, and people want. It's really important for people right now, I think, to feel that their time is well invested in their roles. And people want a little bit more from their careers. They want to feel that they are part of something and that they're giving something back. And that can be in a number of different guises, but that forms into the employer value proposition. So what is the history of your company? Where did it come from? And why are people enjoying working with you, and what are you achieving together? It's that excitement factor which I truly believe exists in all organizations. It's just finding what it is and then making sure that your managers that are involved in hiring can then accurately convey that as you go through the hiring process. And again, back to being in your job advert, being at interview stage, and so on and so on, just reiterating those messages. And then just at the top, hybrid and remote, it's not going to go away. We know it was a key priority coming out of COVID, and there's been some form of balance now where businesses are doing all sorts of different things. I can't deny it is still important, absolutely. And if you can offer it, it's fantastic, because mainly I will say from a hirer's point of view, you can expand your talent pool. So if people are traveling into your office space less, then it balances their time and their costs. So generally people will travel from further. So it's really useful from that point of view. But I will say it is mixed. You have to know your business and it works for your business, or it doesn't. And if you can't offer flexibility or hybrid, then again, it's just really important to be highlighting those other 2 points of what else do we offer, and culturally, why do people want to come into your office? Is that for the office space, for the socials, but what is that? But just really highlighting that. If you can move on, please, Georgie. So earlier in the presentation, I mentioned, or I highlighted slightly, the leadership piece. And it's definitely clear that candidates want clear leadership. And I personally feel, and from what I've seen in the survey, I feel this is because of those sort of cultural points and that employer value proposition for the leaders conveying the message of why are we here and what are we doing. That makes it meaningful. Visible leaders in the organisation, leading by example. And in the survey, it breaks down all the different elements, I guess, that people want from their leadership. What we have found, though, unfortunately, is at the moment there is slightly less confidence in senior leadership. So just 1 in 3 people express confidence in their senior leadership. And again, there's a number of factors that came out of this. There's been quite a lot of movement in leadership, with people reporting a higher number of managers during their tenure with their business than before. And obviously, it takes time for managers to embed. Managers also, leaders, I suppose I should say, are also experiencing their own journey with the business when they join. But it was very important, and more respondents ranked leadership and culture ahead of salary. So it's definitely worth investing in if you're not already. And actually, I do anecdotally hear that from some clients, where sometimes managers are that sort of missing middle. The focus is on the talent coming into the business, and sometimes the managers are sort of left in the back seat. So definitely just really highlighting that. So in terms of that, how that fits into the recruitment process, your managers are representing your business. So they do need to be confident in hiring if they're not already, and they do need to be effectively selling the opportunity to prospective candidates as they move through the process, and that's at interview stage, and then later on at offer stage, and onboarding and so on. If you're lucky and you have internal HR or recruitment, then you have a partner that can fill those gaps and help with training and sit in with you. But if you don't, it's just something important to think about: who is involved in that recruitment process. And one thing I haven't mentioned is, when you're planning your hiring, looking at that timeline, who is going to be involved, are they available in the time in our hiring periods, I guess, or has someone got a 2-week holiday right in the middle of when we need to be having that second interview? Because keeping that pace and keeping candidates engaged, particularly when it's talent you really want to attract and it is competitive, you need to keep that pace and not have sort of big gaps in process. So just looking at who's involved, have they got the tools to be able to deliver on it effectively, and do we need to make provision otherwise? And it's important then those managers can evidence their decisions throughout the process. And that's just really useful. And especially for, as I mentioned earlier, giving feedback to candidates. Giving feedback is really key because it is the candidate's lasting impression of their experience with your organisation. So giving some really useful developmental feedback is really important and sends people away with good experience if they're not selected. And then talking about progression, so you'll see the infographic on the left. So progression was really important. So 70% of people wanted progression, which is really high, I feel. But only 40% of those felt that that was achievable in their business. So there's a mismatch there of 30% who may be disengaged in their current roles because they feel they can't achieve progression. Now, my key highlight for this, and I guess my recruiter perspective behind the scenes there, is to say that you have to bear in mind progression looks different to all different groups of people. So when we're talking to candidates about why they're looking for a new role, we'll often ask and they'll say, well, because there's no progression. And then my starting point is always to say, but what does progression look like to you? Because for some people, progression means money. For some, it means greater responsibility or title or interest in their role because they've stagnated because they've been there a long while. So it's important to find out what those motivators are and to not assume. So if you've got a robust performance management system, you may have that already built in, so you're well aware and you're managing your internal succession plans and internal movement and so on. But if you haven't, they're the sort of things you need to be thinking, because when a client comes to me to hire and it's for a new role, we'll always talk about other options within the business and was there option for someone to move over, or whether it has to be a completely new hire. But there are often options to expand on people's roles, to create that progression opportunity where it might not necessarily just mean seniority or budget at that time. So just think about that. It's a really important point, and that could mean that we have slightly less movement as people get more satisfaction in their careers and feel that there's somewhere to go within your organisation. So this is just a recap of what I've covered today. I'm always happy to talk about anything afterwards. You have my email at the end, and I would say reach out and get a copy of the survey, because it's just really interesting and it will be valuable for anyone managing hiring throughout the rest of this year. But to summarise my key points: give yourself the time to plan recruitment carefully and revise the job description at the outset. Ensure your employer value proposition is clear and consistent and engaging, and you use it. So think about the why. Why would someone join? Why would they stay? Invest in your leaders and your internal talent pool. So look at succession planning, make sure your managers feel supported and they have the tools to also progress and to succeed in your business. And if you are choosing an external HR recruitment partner, choose wisely. Your recruiter or HR partner is an external representation of your business. A client once said to me, you are sort of our external HR team, and we are the people that are representing your business to the wider recruitment market. So make sure your partners have all the tools to be able to represent you adequately, the sell of your role, the sell of your business, the why people should join you, and that's really important. So that is everything I've got to cover today. So I'm going to hand back to Robert to do a wrap up on his side, and yeah, look forward to hearing from you in future if you do need any additional support.
Thank you, Victoria, and as ever, really insightful and thought-provoking content there. I think we won't let Victoria go quite yet because she may need to answer some questions if we've got any. So hang in there for the answers to those questions if we have time. Themes for me through today are the importance of getting your policies and procedures and practices absolutely up to speed and legally compliant. The importance of good, strong recruitment, knowing what you want from a role, investing in the leaders, ensuring you have good leaders and good managers who understand those policies and practices and practice what they say, and good communication across your organizations, ensuring that everyone knows what's expected of them and that they know what's expected of them sooner rather than later. These will all be things that help guard against claims, but when you get claims, we're there to help, but we're also there to help to try to prevent those claims in the first place. And hopefully today's given you some insight around that. And by way of recap on those 2026 changes that are coming in place very soon, we have those day one statutory sick pay changes that Georgie helpfully mentioned and talked through, the day one paternity and unpaid parental leave provisions, and sexual harassment changes in relation to whistleblowing rights, all of which, as I've said, every business needs to keep themselves up to date and abreast of and address. We then had me talking about the redundancy changes. They're things that any business that is considering or may be involved in a reorganisation really ought to be aware of and ensure that you comply and get the advice you need. And the wrap up, hopefully, from Victoria and me in terms of the day one rights that arise, coupled with the 6 month right for unfair dismissal and getting those hires right, is hopefully helpful. Now, before we close today, a couple of things to mention. First, we will get to the questions in a moment. Second, to let you know that there are available follow-up notes that we can share. I think we've got a next 90 days resources from Tees, and I think Victoria, you've got resources that you've mentioned that you're very happy to share, and you have our details there. Please, though, if we have time, Georgie, have we got questions that we can help with in the time permitted?
Yeah, we've got a couple of questions come through. So there's one here for Victoria. We require more office time than some other businesses may do. How much could that affect our ability to attract and secure talent?
It's a good question. It's as I mentioned, it's definitely still mixed, and there are definitely businesses that do require 100% attendance. I think what's really important is just going back to what I was saying about, firstly, the benefits package. So highlighting the other benefits that you do offer, and particularly if people are on site, there might be benefits. Some clients might offer a subsidised lunch in a canteen, or like I say, that dress down Friday, which isn't really a benefit if you work at home. And also looking at your employer value proposition. So why do people come in? Why do they choose to go in? Is that because of your amazing office space, or is it because you're you're a culture of a business that you work very collaboratively and you want that sort of face time together? So it's just highlighting the what you do have and not focusing on the what you don't, basically.
Thanks, Victoria. That's really helpful. We've got a question
Any
for
more?
Rob as well.
Okay, yeah.
So with collective redundancy, am I safe if I keep it under 20 redundancies in 90 days?
That's a really good question, and the way you phrased that in that question, or the question asked about is it safe? Well, of course, as I mentioned, the collective rules apply in relation to that process for 20 or more redundancies proposed, envisaged within 90 days. But you still have those rights to claim unfair dismissal, which would trigger after 6 months going forward from the 1st of Jan 27, and they will apply in any event. So whatever happens, even if it's under 20, meaningful appropriate consultation and ensuring, as I mentioned before, that redundancy is the genuine and true reason is the way to go, and keeping that tally of numbers, because you could inadvertently fall into 20 without realizing it if you don't have that happening. I think that answers that question. Again, the overarching thing is good communication, transparency, and doing the right thing and picking the genuine reason for dismissal and not making decisions on a predetermined shooting from the hip basis.
Thanks, Rob. Have we got time for one more question?
Yeah, I think so. Yeah.
Okay, there's one for me. So if you've received sexual harassment allegations against a senior member of staff, how do they ensure fairness in these investigations? So obviously this is a difficult situation that should be handled with care. And obviously from April, as I mentioned, would also have to be in line with any of your whistleblowing policies. So you need to kind of, as an overall, make sure it's as fair as possible. And this can be done through a really thorough fact-finding mission where you speak to witnesses delicately and gather evidence and try and make this as unbiased as possible, as you would with any other employee. And any decisions that you make and conclusions that you draw, make sure that that's based on the investigation findings, not on any pre-existing relationships. And as we've said many times in the webinar, make sure that all of this is properly documented and evidenced, so that you can kind of prove that you've done this right going forward.
Thank you, Georgie. And I suppose what we speak to there is ensuring that you follow an objective and fair process and that you follow your policies and procedures in place, and for these serious allegations, get advice sooner rather than later, if you need to. So that's just about it from us today. It only really remains for me to thank Victoria and Georgie for what I hope everyone has found really useful content and presentation this morning. To thank all of you for your patience in listening, and hopefully you've all found it interesting and helpful. For the future, we will be holding further webinars with guest speakers. So if you have topics, or indeed if you feel that you would be a good guest speaker to join us, we keep a very open mind to that to keep things interesting for our audiences. And we will be delighted if you can let us know about any follow-up queries that you have. Please do keep in touch with us. Please contact me, Victoria, Georgie, or any of the team with follow-up queries that you have. Enjoy the rest of your day.